ladies and gentlemen. Thank you for joining us for the CIL seminar today on international law and the clash of rights. As we start, I will hand you over to our chair, Ms. Daphne Hong.
Center for International Law, eConference series on COVID-19, on international law and the clash of rights. I have been told by the organizers that 500 persons, which is the maximum allowed on this Zoom platform, have signed up for this session. Thank you very much for the interest you have shown and for joining us today, especially those of you from many other parts of the world. To get us started, please let me introduce our opening speaker, Professor Simon Chesterman, the Dean of the NUS Law Faculty and Deputy Chairman of the Center for International Law's Governing Board. He is also the editor of the Asian Journal of International Law and has been a senior associate at the International Peace Academy and director of UN Relations at the International Crisis Group in New York. Professor Chesterman is the author or editor of 17 books, including on the United Nations. He is a recognized authority on international law, and his work has opened up new areas of research on conceptions of public authority, including the rules and institutions of global governance. Just last week, Professor Chesterman published an article intriguingly titled COVID-19 and the Global Disorder in the Singapore's newspaper, Straits Times, setting out some of his thoughts on the COVID-19 and the clash of rights. Professor, the floor is yours.
Thank you very much, Daphne. It's a great pleasure to be joining this discussion. And candidly, I think the reason I was given the opening slot is to add a little bit of buffer time while additional participants join, work out their technical difficulties. So I'll try and throw some ideas out with an eye to provoking our panelists, because it's really an extraordinary honor to be among these people. They'll get full introductions momentarily, but as I share my screen, I thought the first slide was worth at least highlighting who will be coming. And I'm delighted, in addition to Daphne, to be joined by Ambassador Hmoud, Photini, Pazartzis, and of course my colleague Bob Beckman, who actually interviewed me for my job at National University of Singapore a long time ago. So great pleasure to be with them. So what I thought I'd do in just a couple of minutes is really talk about three things, setting the stage or laying the table, if you like, for the meal that is to follow. So I'll talk a bit about tensions, a bit about shifting standards, and then at least some tentative ideas about where we might go from here in terms of the debate over rights in the context of this pandemic and future crises to come. So let me start off a little bit more lightly, however, given the gravity of the subject matter in terms of tensions. One thing that COVID-19 has really revealed is the similarities that we all have around the world. And so this is a fairly common image, if not an ideal, of people stockpiling the basics of necessity, the basics of human life. And of course, that's something we all share in common. Well, at the same time, national stereotypes have to some extent been played out through this crisis. So in addition to stockpiling things like toilet paper, pasta, and so on, the United States had a run on weapons. As being true to type. In my own native country of Australia, it was a shortage of alcohol as people stockpiled alcohol. While in Singapore, it was a shortage of canes for disciplining children during home learning. So in some ways, we're playing up to national stereotypes. And if you like, that's a very lighthearted way of illustrating a more serious point, which is that this crisis has really demonstrated two things that are contradictory about the global order and yet true at the same time. The first is that we're all connected. This crisis really is demonstrating our shared biology, our shared involvement in an ecosystem, and in many ways, our shared response. The scientific community is cooperating at a speed and with a degree of collaboration really unprecedented in human history. The global media is extraordinarily aligned. We are, in a way, really unprecedented in human history, having one conversation about one goal, which is defeating this virus. And that really is showing that we're all connected. But at the same time, it's every country for itself. That's true both in terms of the efforts we are undertaking to slow the transmission by closing borders, but it's also true problematically in some of the competition that's going on in terms of efforts to get first access to drugs, preferential access to medical care, medical facilities, and the invocation of special powers on the part of countries to arrogate to themselves resources that might otherwise be shared more equitably. So as individuals, most of us are social distancing or safe distancing at the moment. I'm in my home. Most of you, I assume, are in your homes. And that's a necessary individual response to a public health crisis. But when nation states begin to socially distance, the result is that the kind of rhetoric, the nationalist, nativist rhetoric that we've been seeing for the past several years in the global discourse, that escalates very quickly into xenophobia, and racism. And we've seen that certainly in some of the responses. And so those tensions really spill over into some of the accounts of national responses. And so this is from the New York Times Twitter feed in March, where China was undertaking measures to quarantine. This is with respect to Hubei, and the great cost to people's livelihoods and personal liberties. Literally the next tweet, minutes later, was a story about Italy, which said that Italy was risking its economy in order to contain the coronavirus. In other countries, we've seen similar analyses. Just to pick another example, when China rolled out surveillance software, it was said to be alarming human rights advocates, whereas at least in many parts of Europe, there's already been a move away from a pure rights-based analysis to an effectiveness analysis in terms of the ability to track our ability to contain the virus through tracking apps and so on. So those tensions are really on display, and that makes it problematic when we look at the shifting standards, because very quickly people who would have abjured any kind of restriction of movement are now saying it's insufficient restriction of movement. Those who would long have prioritized privacy are now saying, well, it's not effective enough in terms of the tracking apps. And this is really a vacuum of leadership at the moment. To some extent, we are seeing commonality of behavior in terms of the scientific advice, but really there's an absence of global leadership. In a time like this, we might have expected someone like the United States to step up to that role, although unfortunately it appears that the President of the United States wants to be more the center of attention rather than the center of an initiative, a global initiative, where the United States in previous regimes might well have played more of a leadership role. China episodically tried to step up into that role, engaged in various good officers' efforts to raise its profile, to be seen as helpful, but that suffered some missteps in that. The international organizations have been revealed as weak. One thing that's often not understood well in the lay population is that these international organizations are designed to be weak. It's not an accident that the World Health Organization is unable to act without consensus of its leadership, that it's unable to defend itself against perceived political attacks by political leaders around the world. That's how these organizations are designed. Larger bodies like the General Assembly operate by consensus, which is why they can generate resolutions as they have, as the GA has, but largely platitudinous. So there was a General Assembly resolution adopted by consensus, ensuring, or rather calling for, widespread access to a vaccine when there's a vaccine. Although it seems that that resolution was only passed unanimously or by consensus because the United States failed to block it. The Security Council itself remains conspicuously silent at the moment. There have been a couple of draft resolutions going around. France and Tunisia, I think, are trying to nudge one forward in the next couple of days. But the main point of division has been the United States unwilling to include any recognition of the World Health Organization, something that China wants to push for, while the US is pushing to include references to transparency linked with its calls for some kind of investigation of China. And so in its place, the problem is there's no one to trust. There's no one in an obvious leadership position. And what we've seen instead is episodic leadership. So we've had the World Health Organization playing something of a role, but often it's been individual countries. And so Korea, Taiwan, until recently, perhaps Singapore playing leadership roles. We've had extraordinary leadership by people like Jacinda Ardern in New Zealand, to some extent Australia. And so that is a real crisis of leadership, because it comes at a time when we need leadership at the global level, but trust in public institutions is at an all-time low. And it's possible for global orders to be reformulated because of the lack of trust in institutions. And just one example of that in recent memory is the whole Brexit debate in the United Kingdom. And many of us might look back fondly when Brexit was the biggest thing we were worrying about. So where might we go from here? What might come next? Well, one of the challenges is that when we're in the middle of a crisis, it's a particularly bad time to try to predict what's going to happen next. But it is striking that at the international level, crises have tended to be the only times when it's possible to enact large-scale change. So the only reason we got the League of Nations was because of the First World War. The United Nations was a byproduct of the Second World War. It's only during these times of real crisis that nations are prepared to make sacrifices to reach compromises. And so it's conceivable that one could have new institutions formed. It is conceivable that there might be a groundswell of opinion to say, well, we need not a World Health Organization, we need a World Health Council with powers comparable to the UN Security Council. Candidly, I think that's unlikely. What we're more likely to see is some new practices. And this kind of leadership by countries such as Australia, New Zealand, Taiwan, South Korea, suggestive of what a colleague of mine at the Lowy Institute in Australia, Michael Fullerlove, calls coalitions of the competent. And so it is possible that one of the things that might happen is that good ideas might gain their own traction. And I've put up Greta Thunberg there because there's a slim possibility that we apply that to other crises, such as climate change. In the short term, however, two things that I think are likely to increase. One is inequality. And much as many countries are worried about the possibility that their emergency rooms will be overwhelmed by people and there'll be a shortage of ventilators, there are countries in the world, such as Somalia, that don't have a single ventilator. And one of the consequences of this crisis is likely to be a diminution in aid and assistance. There was a massive effort to try and raise money in Europe to support the World Health Organization, raised something like $8 billion this week. Conspicuously, the United States and China both stayed away. So I fear inequality is going to increase. And something that's certainly going to increase is surveillance. This, as I said earlier, the crisis has really diminished some of the reservations about surveillance that had long occupied many people who were wary of the rise of surveillance. But most people, I think, now are accepting that dealing with the crisis over the coming months, potentially years, is going to require some kind of tracking, some kind of surveillance. And the challenge now is how to do that both legitimately and effectively. So let me conclude with, I've been talking about crisis. Let me conclude with just a brief excursus on the word crisis. This is weiji, the Chinese term for crisis. And it's striking that one of the things that's really typified many countries' approach to this challenge legally has been the invocation of emergency powers. We've had countries like Israel, Turkey, embracing emergency powers, really treating this as if it were a military threat, as if it were a national security threat, and invoking those emergency powers. Other countries like Singapore, partly because of the experience of SARS, already had laws on the books through the Infectious Diseases Act that it wasn't necessary to declare a formal emergency. And I put up the Chinese term for crisis because it's well known but mistaken that crisis in Chinese is a combination of two characters, the first meaning danger, the second meaning opportunity. And this has become a trope of motivational leaders around the world. You've probably heard the same speech or a version of it. And this really goes back to when John F. Kennedy was running for president in the late 1950s in the United States. It's a wonderful image. It's a compelling story. Unfortunately, it's wrong. Because the second character doesn't really mean opportunity. What it really means is a crucial moment or an incipient point. And I think that although none of us should be regarding the current moment as an opportunity, there's no doubt that it is a crucial moment in global history. Crucial, most obviously, in terms of the human tragedy unfolding in many countries that have lost way too many individuals, but also crucial because it's testing which aspect of that tension I pointed to earlier is going to hold out, which is going to be dominant. Is it going to be the fact that we realize we're all one community, we are sharing this experience, the threat is shared, and if we want the global community to return to any kind of normal, we need to address it together? Or is it going to be something that we address through retreat, through returning into our individual nation states with predictable consequences? And this is particularly important in terms of how we think about rights and the clash of rights in this situation, because one of the reasons why countries have emergency powers is to distinguish normal from emergency. And when those special powers are invoked, it's meant to be for a temporary period. And the key question that I'll round off with is whether the kind of powers that we're seeing invoked, in particular in the areas of surveillance, but also in other areas that challenge traditional conceptions of rights, will that come to be seen as exceptional, or will that come to be part of our new normal? So just some thoughts to try and provoke discussion, but like all of you, I'm looking forward to what our panel has to say in the coming few minutes. Thank you.
Thank you, Dean, for the very thought-provoking presentation, which nicely sets the stage for the panel discussion to follow. Now, let me introduce our very distinguished panelists, starting with Ambassador Mahmoud, the Jordanian ambassador to Singapore. He has negotiated several bilateral and multilateral agreements on behalf of Jordan, acted as counsel for Jordan in proceedings before international tribunals, including the International Court of Justice and the International Criminal Court, represented Jordan in regional and international meetings, and participated in international law and political panels in various fora and universities worldwide. Since 2007, Ambassador Hmoud has been elected 3 times by the UN General Assembly as a member of the International Law Commission and served twice on its bureau. Our second speaker is Professor Photini Pazartzis, Professor of International Law and Director of the Athens Public International Law Center at the Faculty of Law of the National and Kapodistrian University of Athens. She is and has been a member of the UN Human Rights Committee for ICCPR since 2015 and is currently its vice chair. She is also the president of the European Society of International Law since September 2019 and member of the ESIL board. Last but not least, we have Professor Robert Beckman, who is the head of the Ocean Law and Policy Program of the Center for International Law and was the founding director of the CIL. He is also an associate professor at NUS Faculty of Law, where he taught ocean law and policy for many years. He has published widely on ocean law and policy issues. He is also a senior advisor to the Maritime Security Program of the Institute for Defense and Strategic Studies at the S. Rajaratnam School of International Studies at Nanyang Technological University, and a member of the governing board for the Rhodes Academy of Oceans Law and Policy. And may I also add, personally, that Professor Beckman taught me public international law and United Nations law. So let us move to our first panel session. And I will start by posing a question to Professor Beckman. In response to the COVID situation, we have seen that the first reaction of many states was to close its borders in order to block the virus coming in, or in Singapore's lingo, we call it, in order to prevent the virus from being imported into Singapore. We have also read reports of countries refusing to allow cruise ships to dock at ports and turning away crew members and passengers. Prof. Beckman, what is the international regime governing the maritime industry, And are states allowed to impose such restrictions?
Okay, thank you very much, Daphne. I will dive into that issue. It raises questions of clashes of rights in the sense of right of foreign ships to enter ports, right of passengers and crew on ships to receive medical assistance from a port state, right of the seafarers to either leave a ship when their contract is up so they can return home or to join as a new crew member. And contrasted to that, the right of port states to impose restrictions on the entry of persons and ships into their territory at the time of a public emergency. So we can look at it from that perspective, but we can also look at it from the point of view, is it simply gaps in international governance? Your framework convention would be the Law of the Sea Convention, setting out in general terms rights of coastal states, port states, flag states. But then you have at least 3 international organizations that are relevant to this. The World Health Organization and the 205 International Health Regulations, the International Maritime Organization, which governs international shipping, and they have detailed conventions on safety of navigation. They deal with port state rights and port state control. And the International Labor Organization comes in, particularly with the Maritime Labor Convention of 2006, setting out the rights of seafarers. So I guess the question we have in terms of rights, how I would answer the first one is I would say a port state has a right to deny entry to foreign vessels into its ports in time of national emergency, medical emergency, or the international health emergency. On the other hand, there might be an exception to that, is if the ship is in distress because either passengers or crew members are in urgent need of medical assistance, then they would impose an obligation on the port state to, if not let them into the port, at least provide them through their own doctors in internal waters or off their coast with medical assistance that's required. So in that sense, we can look at it as a clash of rights. On the other hand, I tend to look at the overall issue of what we've seen with cruise ships and the difficulties they've had in Australia, US, and other countries, and the issue of crew changes. If you read the literature coming out, there's more than 1 million seafarers at sea. Often they're ending their contracts and they would normally come ashore and then fly back to their country of origin, which is usually Philippines or Indonesia or India, but they're not able to leave the ship now because of the restrictions imposed by ports. So they're under great stress. Their shipping companies are probably continuing to pay them, but as articles are coming out calling them prisoners at sea because they're not able to get off the ship. Normally the contracts would end after 6 to 9 months. I think the MLC requires a maximum of 11 months, but there are seafarers that are going to be at sea much longer than that. So that again raises issues between their human rights, ship owners and flag states not being able to comply with the requirements of the Maritime Labor Convention. Arguably, they would have a ground because it's impossible for them to comply to give them the leave required and so on. So these are some of the issues that arise. I would like to look at the issue from the point of view of international governance, and were there gaps, and then can those gaps be filled? And it's not so much it's not so much in Simon's view a question of who leads, it's the international organizations that should be leading. And I would argue with respect to shipping, it's the IHO in terms of declaring that a public health emergency of international concern. That didn't come till the 30th of January. They eventually declared it a pandemic on 11th of March. And then the issue is, what did the relevant international organizations do between 30 January and 11 March? What more could have been done? By 30 March, the WHO said there were 7,800 cases. By 30 January, by 11 March, when they declared a pandemic, there were 220,000 cases in 114 countries. So between those, the minute they declared it a public health emergency of international concern, then WHO should step in. They're the ones that declared it. And then the question is, what's the role of the International Maritime Organization? What is the role of other organizations? The IMO came in for the first time on 19 February, which is 3 weeks after, almost 3 weeks after it was declared a public health emergency. They also issued, first time I've seen, a joint statement with the IMO and the WHO together. And then they put various statements out on recommendations and precautions to minimize the risk to seafarers, passengers, and so on. So they moved fairly quickly, although one could query whether there weren't emergency response plans in place where this whole reactions of WHO and IMO could have been triggered much earlier. In terms of, I think the critical date would be once it was declared a pandemic. That seems to be the time, which was 11th of March. Then the question, that's when states started to close their borders, to stop air flights and to stop ships coming into their ports. At least cruise ships. 2 days after the pandemic was declared, Singapore ceased all port calls for cruise ships in its port. Another 10 days later, they said no more short-term visitors were allowed to enter transit Singapore from either flights or ships. Crew changes from ships were disallowed, but the port remained open. It's just that the crew members could not leave the ship, and new crew members couldn't join, or the crew members at contracts that expired were not able to leave. A few days later, on 27 March, they eased up on that rule slightly by saying individual ship owners can make special requests to the Maritime and Port Authority of Singapore for crew changes for special circumstances such as death in the family or other extraordinary circumstances. They may let individual crew members off. So this is again that sort of clash of rights in terms of coastal state imposing. But again, as I said before, I think most states would say there is a coastal state, any state has the right to deny entry to aliens on a public health emergency, at least on a temporary basis. On the other hand, they should provide medical assistance. There were some pushing and shoving between the United States and cruise ships, between Australia and cruise ships, but eventually most of the cases were worked out, although the Australians let one ship in and caused a lot of the cases that they had because perhaps passengers were let in without the necessary screening. In terms of denial of entry to seafarers on cruise ships, this is an issue which is going to have to be addressed eventually. This is an issue where I think I'll pick up a comment from Simon on the coalitions of the competent. Every state, especially a state like Singapore, has a vital interest in keeping commerce moving, and therefore I think that ways and means are going to have to be found between ship owners and major port states in order to allow changes of crew members. How exactly that's going to work out, whether there are special considerations and having them check to make certain they're not infected. And then sometimes the ship owners would actually pay for a charter flight to send them back to India or Philippines. Both Philippines and India are trying to take special measures in order to get their crew members back. But these are an issue where I think major port states would see they have a common interest in keeping trade moving and keeping seafarers that are rested and have their basic rights protected on the ships, on the commercial ships. Maybe I'll stop there and see if there's any questions in terms of the international regulation.
Prof, before,
You got to unmute.
okay, Prof, before you do that, we'll have an opportunity for question and answer later. In fact, I see many questions have already come in. But before that, let's move on to our second panelist, who is Professor Photini. Okay, Professor Photini, we have seen many states around the world imposing lockdown, including very stringent measures restricting movements in a bid to contain the virus and flatten the curve. These measures were imposed to essentially protect public health and human lives, and if I may say, they appear to be effective from a pandemic control viewpoint. What are your views from a human rights law perspective on these measures and their defensibility?
Thank you, Daphne, and thanks to the organizers for giving me this opportunity to attend this webinar, this conference. Greetings from Athens. The short answer to your question, Daphne, is that human rights are also being quarantined at this moment. And what I mean in particular, I refer to civil or individual freedoms. And that's a short answer. But there are longer answers, of course, and we need to, when we will need to in the future, in the coming future, address these. Now, the basic issue to respond to the answer that you ask is that right now we are witnessing a clash of rights, as all my colleagues who have spoken have already said. And the question is how to navigate between these rights and these conflicting rights or freedoms. This pandemic, the COVID-19, has actually engaged or is engaging a full spectrum of rights. Professor Beckman just told us about maritime and wayfarers' rights and sea rights, but all these have to do to a large extent with human rights in general and international human rights protection. So on the one hand, we have the protection of the right to life and health, in particular the right to life, and the positive obligations that states have, because they do have positive obligations under international human rights law, to address, to take measures, to address, to protect life, to address general conditions in society that may give threat to life, including, of course, health pandemics, such as the unprecedented one we are witnessing right now. So states do have obligations to mitigate, to prevent as far as possible all the negative effects on the right to life. But again, there is an international human rights framework, and states are obliged to work under this framework, so to speak. What we are witnessing right now is a risk or a danger, I have to say, that the responses of states up to this point, of course, lead to affecting, if not violating, other individual rights and freedoms. I was reading this current discussion on the use of contact apps. If I understand correctly, it's been used in Singapore or other places in the eastern part of the world. States consider this a means as to fulfill their positive obligations to protect health of individuals. But this does raise the question of how new technologies might impact other rights, and questions whether limitations to other rights are lawful, necessary, and proportional. So this is the response we are seeing up to now, and I think also what Professor Beckman said shows this, is that states have been addressing the pandemic with a common denominator of restricting individual rights and freedoms in various fields. And mainly I'll focus on civil and political if you wish, but I mean, we see lockdowns, we see prohibitions of large gatherings, even prohibitions of activities. In my country as well, we had a lockdown for the past 2 months. I'm speaking to you, I'm still at home. Closures of businesses, closures of schools, places of worship. So the list can go on. So this brings me to a second question, Daphne. I will just briefly raise 3 more points, apart from the first one you raised, which is general. My second question, which we need to think about, is does this pandemic, which is severe, which is extreme, which is unprecedented, justify restrictions or even abrogations of human rights obligations? And of course, there's an answer in law which says that, of course, limitations to those rights that are not absolute, that are not non-derogable. Okay, limitations are permissible under international law, usually specific, right-specific limitations and for various rights, and provided, of course, that these have a legal basis, that they pursue a legitimate aim, and are necessary and proportional. So then some instruments, international human rights instruments, such as the ICCPR, the European Convention of Human Rights, the Inter-American Convention of Human Rights, also provide for more extraordinary measures. So these are the derogations, and this is what is being talked about to a large extent here in Europe and within the UN. So these are extraordinary measures that allow states to derogate from human rights obligations, of course, in very exceptional situations where there is a threat to the life of the nation usually. And, we can put the pandemic within this extraordinary situation. So, so we have limitations to certain rights which are permissible. We have a specific regime of derogations, which is a more stringent regime, if you wish. But of course, again, it doesn't touch non-derogable rights. But what we are witnessing now is we are living in a period where these limitations, especially the derogation systems and regimes put in place by these various instruments, are becoming an alarming phenomenon. I mean, states seem to be resorting to these measures, and they seem to be becoming the normal reaction. And I think I would agree with what Simon referred to in the beginning, and I will come to that, and that was one of my points, that the issue of temporality will have to be addressed at some point or another. Apart from these regimes, and that it's happening, I think, in your part of the world and other parts, states resort to domestic emergency powers, like I understand has happened in Singapore, to domestic regulation, which provides for this possibility. So to come to my third point, the issue is and will be, and we don't have responses yet. What we have are some maybe some guidance to how these issues will be approached. The legality of such limitations, suspensions, or abrogations. And the essence here is goes back to the content of such restrictions and how a restriction will be considered an abuse of power, how it will be considered as arbitrary, or how it will be really considered as, for example, not a limitation. Take, for example, the freedom of movement, not a limitation to the freedom of movement, but it could lead to even detention, which could be arbitrary. I mean, so you see that there's linkage and steps that we will need to follow closely in order to see how various restrictions, and that will have to be done on I think, on a case-by-case basis, if I may. I don't know if we can give responses, the responses that Simon asked in the beginning, if we do not see a case-by-case basis. The discussion right now, if you wish, in my part of the world, is there a choice? What to choose? Should we choose derogation regimes, which are identified in some human rights instruments? Should we just resort to the normal limitations? There's a big discussion, for example, between Martin Scheinin and Alan Green. If you opt for official declarations of emergency, there is a control over this, but there's also control in many mechanisms, a judicial control of limitations, even in situations of normal, if I may, restrictions to some rights. Now, what is interesting on this point, and I'd like to bring it to the discussion, I think I have a few more seconds and then I'll finish up. What is interesting is that we see in various fora that standards which should be applied or which are to be applied are being reminded to states. We see the Council of Europe taking position on the issue of derogations. We see the Human Rights Committee, and here I'll talk on a personal, of course, in my personal capacity and not, but the Human Rights Committee also issued a statement a few days ago on the limitations and derogations to the covenant, the International Covenant on Civil and Political Rights. And we see a reminder everywhere, the Inter-American system as well, of the standards, which are standards of legality, necessity, proportionality, and I will say also a strict interpretation of limitations, and the recourse to limitations which are the least restrictive to achieve public health goals. From all of these, as I said in the beginning, I think the issue of temporality will be very important as we go on in the future. And that will bring me to my final point. Of course, there are implications for the human rights system. We are witnessing these, domestic and international, I would say, because let's not forget that not all regions of the world are covered by the instruments to which I referred to previously. But of course, we do have international human rights standards that cover, I think, are applicable everywhere. But one thing that we will probably need to be aware of as we go forth is that apart from looking to future-oriented approaches, and there I would agree with Simon Chesterman, to the global health sector, and a proactive approach maybe to third right generations, which are such as the right to health. We will need to be aware of the temporary measures being slowly or inadvertently becoming normal measures for the future. So that is something that we will need to take on board, I think, and be cautious. And as to the rest of how potential claims might be assessed, be they in any field of human rights, that remains to be seen from the way jurisdictions, I mean, domestic, regional, and international courts will respond and will apply these standards. So these are the few remarks I wanted to make coming from a human rights perspective. And thank you very much, Daphne and everyone. I can't hear you.
Thank you, Professor. I see there are already questions for you later. But before that, let's move on to our third and final panelist, Ambassador. Okay, Ambassador, we have heard the speakers earlier speak about how states first started blocking access and keeping the world out, so to speak. And then moving on to even within their borders, imposing stringent movement controls on its population. So we have taken a look at the response of states. Let us now move on to the international stage. Ambassador, can you share with us what has been the response of the United Nations to the pandemic? And in your view, how effective has this response been? In particular, in getting countries to work in concert to combat the virus, so that it is not a situation as Dean has described it as each country an island unto itself.
Center for International Law for organizing this important and timely event. I'm honored to be with this panel, Professor Pazartzis, Professor Chesterman, Professor Beckman, and I've enjoyed listening to your interventions. In short, we have to take into account the element of time. It's been only a few months, so it's very hard at this stage to judge the UN system and its effectiveness at this stage. But till now, it can be said that actions taken by the UN and its organs were not coordinated. They lack clear or coherent strategy based on set operation and legal principles. Again, this might change over time. We can see more or different approach in this regard. We start with the Security Council, and as Professor Chesterman said, it didn't take any action to combat the disease despite its vast authority and the binding nature of its decisions. The Council in recent years has included in its agenda and adopted resolutions matters which do not traditionally fall within its traditional functions, including on women, peace, security, children, armed conflict, climate change, rule of law. I don't know why this is different. COVID-19 is not a traditional function of the Council, but it endangers international peace and security and warrants a response by the Council. The SG, the Secretary General Guterres, in 9 April 2020, described the crisis as a threat to the maintenance of international peace and security and the gravest threat of the world since the founding of the United Nations. If this doesn't warrant action by the Council, I don't know what does. The GA was more forthcoming. They adopted 2 resolutions. The first, resolution 74/270 on global solidarity, and this is a very important aspect at this stage and hopefully for the future. And the second was, which also Professor Chesterman referred to, the international cooperation to ensure global access to medicines, vaccines, and medical equipment to face COVID-19. The first resolution contains elements for a framework of global response, although in my view, it falls short of setting a principle of solidarity as its title suggests. It recognizes the threat to human health, safety, and well-being caused by COVID-19, although it does not describe it as a common concern to humanity, which is very important if you want to have legal implications in the future by the international community as a whole. The resolution also stresses the central role of the UN, the need for multilateralism, international cooperation, and the vitality of the respect of human rights and non-discrimination in the response to the pandemic. And these are two important areas. Professor Pazartzis has talked about it and referred to them, and the possibility of abuse of power by states in this regard. So it is important that the human rights dimensioning be included in an international response in this regard. It provides two substantive elements of the resolution that may lead to legal effects over time, not now. The commitment to help people and societies in special situations, and a call for intensified international cooperation, including by exchange of information, best practices, knowledge. The resolution also recognizes the assistance offered by governments to others in the spirit of solidarity, although it doesn't call on governments to do so, and people who know exactly the schism that happens between developing and developed states with regard to the issue of solidarity right to receive assistance. They see that the resolution lacks any mention that even calls on states to provide assistance. Resolution 274 on international cooperation with regard to global access to medicine. This is a better step in this regard, and Singapore played a central role in its adoption, as I understand. Also reaffirms the central role of the UN system in the global response and supporting member states. It requests the Secretary General to report on recommended options with regard to fair, equitable, efficient, and timely access to medicines, equipment, and future vaccines. And here I reiterate the issue of equitability, or with regard to access to the medicine, in particular for developing states. It also calls on states to strengthen scientific cooperation, bolster coordination in this regard. Its preamble, sets out the underlying principles, namely the right of every human being to health, the importance of international cooperation and multilateralism, and the priority of equitable access to health products. It did not identify commitments on member states which may develop to come obligations as such, but it also can be a basis for future possible instruments if the international community decides to do so. The SG also issued several reports, and he's been very active, and the Secretariat has been very active, and that's something they are commendable, can be commended for. He released a report on the UN framework for immediate socio-economic response to COVID-19, on human rights and the disease, on debt and COVID-19, on the shared responsibility and global solidarity with regard to the socio-economic impact, and establishing a fund, the UN Response and Recovery Fund. Those reports and initiatives provide for important principles and benchmarks for response to the pandemic, but it remains to be seen whether they can induce states and other global institutions to act in concert to combat the disease in an effective and institutional and right-based manner. They also do not identify legal basis to underlie obligations towards access to medicine, international cooperation, humanitarian assistance, or sharing information of scientific knowledge and information. While the UN response has been, quote unquote, emerging, the global response to COVID-19, at least on the bilateral level and certain multilateral level, has been promising. And I note here a recent event, the International Pledging Conference organized by the European Commission, held, I think, nearly 2 days ago, raised 7.4 billion euros to develop vaccine and treatment for the COVID-19. This is promising and shows that actually people realize that in case of global emergency as such, you need leadership. And it does not have to go from one quarter. It can go from different quarters, and it can be through bilateral, multilateral, plural events, regional events to do so. States have been cooperating in exchanging medicine, medical equipment, and facilitating access through their territory to humanitarian emergency assistance. The states have also accelerated the exchange of information, knowledge, know-how about the virus and possible treatments. While bilateral, multilateral cooperation has not been even, and obviously there's examples where states were blocking the passing of aid from their territory to another country, or from their companies. But overall, there has been progress, which is, as described as earlier, is promising. And this can be a basis for UN or multilateral global effort to combat the pandemic. To deduce elements for such a framework, which may be achieved inter alia through a legally binding instrument, we need to look into existing legal principles as well as those contained in binding and non-binding instruments that might be applicable to the situation. And it doesn't have to be a legal instrument. It can be a declaration. One instrument is, and I have to be look favorably on the work that the Commission, the ILC, has done, is the work on the draft articles, 2016 draft articles on the protection of persons in the event of disaster. Bearing in mind that COVID-19 is a form of disaster, as defined under draft Article 2 of the draft articles, certain legal principles should apply mutatis mutandis to the legal instrument on the response to COVID-19. The draft articles in the preamble talk about international solidarity. They also, as I said, there's been significant debate in the international community on the content of the principle, its binding nature and its extent. But the statements made in the past few weeks on the international level make it clear that this principle is indeed a guiding principle which should produce certain legal effects. The draft articles also talk about sovereignty, and this is a key issue. During the negotiations of the draft article within the Commission and the Sixth Committee of the UN, there was talk about it and whether, to what extent sovereignty and rights coexist. I mean, human rights and sovereignty can coexist. The traditional thinking still prevails, that sovereignty directs assistance, directs relief, directs response. But this is shifting. And if you look at the draft articles themselves, it's a human rights-based draft article. So sovereignty is reflected in what we call as the role of the state, as a responsibility, as a duty, but not as an exclusive right or absolute right to do whatever you want. And that's very important. As I said, it's a human rights-based approach in the draft articles that emphasize the right of persons in the affected state. And this could guide any instrument on COVID-19 response. And from the current global response, there seems to be general support for a rights-based approach, in my view. Also, draft articles talk about the respect for human rights, human dignity, non-discrimination. This is very important because we are seeing trends that countries go inward and try to protect their citizens. The protection, human rights are to protect people on your territory first, and second, it's not only connected to the territory. Obligations under relevant human rights treaties, and Professor Pazartzis can describe it more and better than I do. It goes beyond your territory with regard to your obligations and under the relevant conventions. The third is the duty of cooperation. And please, Ms. Hong, cut me if I'm too long, but I think it's a duty under customary international law. It is existing and it was reflected in the draft articles. So basically, it is something that if you include in future instruments, it means that essentially it is something that has to be respected as such. The duty, the right of states and assisting actors to offer assistance. This is also mentioned, and I note here that this provision is formulated as a right, not as an obligation. But the general duty of cooperation, as just mentioned, goes two ways. And thus it provides for such an obligation on states to assist the affected state. This is important to remember when discussing whether states that have capacity to do so can withhold relief, scientific knowledge, and expertise from the affected state. Obviously, it talks about the central role of the UN system in coordination of the response in the international community. UN system is very important as such in the coordination, but we need to identify exactly what this role is from previous experiences with regard to disasters. Other elements that I can also talk about that can be included in the draft articles, as I said, we need to, in the draft instrument that can be created, that the COVID-19 is a common concern to humankind. Obviously, this triggers certain obligations ergo omnes, which allows the international community to act in concert against the violator. The duty to share knowledge, know-how, and scientific and medical info is something that can be provided for in the instrument, because we need to be specific about this. If you go into general obligations, this is where states can escape from implementing their specific obligations. So you have to specify these obligations. The provision of certain rights to specially affected and vulnerable groups, and this is very important. Refugees are left out, internally displaced, the elderly. The SG was talking about the elderly a couple of weeks ago, if I'm not mistaken. These are groups are become most affected during these situations, and you have to care for them and not to be forgotten. Obviously, we have to put standardization and standard setting with regard to prevention, information sharing, disclosure, reporting, and risk reduction. And obviously, I'm in favor of obligation to offer assistance, but then we have to decide, is it by the international community? Is it by the UN? Is it by individual states? Who is the subject of this obligation? Obviously, the intellectual property rights issue, and I think that has to be negotiated, these provisions with WIPO and with the relevant actors, and I don't think that we have to we create exemptions on the patent regime, international patent regime. I don't think this should be the case, but and there is a regime for compulsory licensing that can be applied, which is also through the ordinary rules. It doesn't have to be exception as such, and but then it's not my area at the moment. I think it's WIPO can help more in negotiating this. And finally, on state responsibility, among other things that can be put. The nature of obligations breached, obviously the consequences of the breach, and whether there's existing customary international obligations related to COVID-19 that can be codified and as such create responsibility. Thank you. I'm sorry for being a little bit long.
Okay, and I see that we have got many thought-provoking questions. Okay, let's begin with a question which I think is directed to Professor Beckman. This is a question from Min Tran. Professor Beckman said that the coastal state is entitled to deny ships to enter into its ports. Is there any procedural requirements or conditions attached to the invocation of this right? Example, prior notification or due publicity. If the denial comes as a surprise or in an arbitrary manner and causes financial hardship or damage to the ship owners, does the coastal state bear state responsibility to compensate? Professor Beckman?
With seafarers, this is not with the cruise industry. This is with stopping seafarers from entering.
Stopping vessels from entering.
Stopping vessels from entering.
So the question is, will the coastal state bear state responsibility to compensate the ship owners?
I doubt it. I think the coastal state would argue it is its prerogative. I think the legal issues would come in if they deny medical assistance to people that are in need of medical assistance, either crew members or passengers. But I would assume that when states are denying entry to vessels, they would give probably at least 12 to 24 hours notice. Then the problem is where is the vessel going to go? And we have the private shipping lawyers are going to have a field day because of delays of cargo being delivered and whatever. There's all kinds of private obligations, but I don't think it'd be very difficult for a ship owner to try to bring a claim against the state for delaying or denying entry on the grounds that it must deny entry in order to protect its own citizens at the time of an international health crisis. I have serious doubts as to whether they don't owe an obligation to the ship owner. They owe an obligation, and many to the flag state. Now we're dealing with rights of a ship, state-to-state rights. It would only be the flag state against the port state, and I don't know of any regulations that you could argue the port state has violated in that circumstance.
Okay, thank you, Professor. Our next question is directed to Professor Chesterman. And the question is, what is the suggested assessment and decision-making procedure for ending measures of surveillance if some kind of surveillance is used temporarily?
Thanks. So this actually brings up a point that Photini was raising also, which is the temporality question. So the whole idea of an emergency, if one embraces that lens, is that it's a temporary departure from the norm. So many people would trace its history back to the Roman idea of the dictatorship. And so Rome, the dictator, this lasted for hundreds of years in Rome, the dictator was an institution. When there was a threat to the life of the nation, you could appoint one person whose word became law, and they could detain people, they could take resources, they could almost do anything they wanted with two limitations. One, they couldn't change the law itself, and two, the institution only lasted for 6 months. And indeed, it was the fact that Julius Caesar tried to become a dictator for longer than 6 months that ended up getting him killed. So that suggests the importance of an emergency, if you embrace that lens, having a beginning and an end. And so we've seen some countries like Spain, for example, has had a repeated cycle of declaring an emergency. But to me, it raises two questions. One is whether one thinks of this virus as an emergency. And it's striking that the different language you hear around the world, various leaders talking about this as a war, or using very much language of national security. And that's one lens through which to view it, although I think that unhelpfully leads to a kind of us and them approach, because most wars are fought against an enemy, there is another. A different approach is the public health, that it's all of us in there together. And I think for hopefully obvious reasons, that's desirable. The second thing I'd say, though, is that it goes really to the heart of this panel discussion about the clash of rights, because how one frames these questions becomes very important. And when, for example, it's liberty versus security, or your right to life versus your right to privacy, usually the liberty interest tends to lose. And so just in recent memory, most of us have been following, I assume, debates over counterterrorism powers. And there is pretty good evidence over the last 20 years, because of the perceived and real terrorist threat, surveillance has increased around the world. And one question is whether that's going to happen here in the next decade or so, dealing with pandemics. So to answer the question, the key thing in terms of having an endpoint is specifying that endpoint in advance. Because if all you do is create these powers without an endpoint, then the tendency is for many countries, as we've seen with counterterrorism activities, when you establish these rules, unless there's a defined endpoint, a sunset clause from the outset, what government voluntarily wants to give up those powers? I mean, that's why we generally have constitutional rights in the first place, that at times of quiet, you get governments to give up powers that they perhaps can only exercise in times of crisis. But that very definition, that use of language of crisis or emergency, requires us to think in terms of a beginning, a middle, and hopefully an end.
Thank you. This question is posed to all speakers from, I hope I'm pronouncing the name correctly, Lizaveta Vova. And here goes. Good afternoon, dear speakers. Many thanks for your outstanding presentations. My question is to all of you, if you please, in times of confronting global governance, which international organizations are capable of creating new global practices to stop further derogations in conditions of imbalance of global economy and singular obligations of states due to their chosen role before pandemic? So which international organizations are capable of taking the lead to create new global practices to manage this situation? We have seen WHO coming under severe criticisms. UN Security Council has pretty much been absent. So which international organization do you think can play a leadership role? Maybe we start with Professor Photini, Pazartzis.
Well, you mentioned them. I mean, the organizations we have are there. I don't know whether we need to consider creation of new organizations, or rather strengthening of the institutional mechanisms of existing ones. So, I mean, I don't see other organizations, you know, except the United Nations and its subsidiary organizations, in particular the WHO, but we see the problems that the WHO is facing from its own membership. So I'm not sure that, you know, creating something different will actually resolve the issues, rather than strengthening what we have in existence.
Maybe just to jump in with the sentence, flipping it on its head, I think there's no question that withdrawing funding from the World Health Organization doesn't seem to be a rational or helpful response.
Ambassador, do you have a view on this?
I've touched on this in my presentation, but no, it has to be the UN, obviously, and the UN system in general, whether it's the World Health Organization or UNO as such, and it depends on the functions. Each, OCHA, for instance, the UN has specific humanitarian role that plays in emergency. The UNRWA UNHCR or other refugee organizations. So each has its own functions that has to be applied. But the thing is, and we have to be frank about it. There's lots of politics that go into the UN system that have to be taken into consideration. This is something, something coming from a person who worked the UN and at the UN for more than 20, 25 years. So this has to be sorted out. Responses haven't, been uniform at the UN system. There is criticism. Some of it is unwarranted and politicized, but some other is warranted as such. And we couldn't be in this situation if there was some more courage on some actors within the UN system to confront what happened earlier. People are afraid of big actors and big countries, superpowers when dealing, and there's lots of diplomacy that trying to appease, and this happens a lot. So that's less diplomatic from me, but that's something that has to be said. But if somebody is to lead, it is the UN, definitely.
Thank you. The next question is from Kuala Lumpur's Jana Kopo. And the question is, and I think Ambassador has also touched briefly on the question of intellectual property rights. The question is, I wonder if the panelists could comment on the equitable distribution of an eventual vaccine or cure. What is the international human rights perspective here? Are the current legal instruments up to the task? What is the role of international organizations in this respect? Maybe we start with Professor Pazartzis.
Yes, and thanks to Karalabos. It's Greek, actually, for the question. Just a minute there. I lost my train of thought. But there are existing instruments, or rather, there are existing standards or rules within international human rights, including non-discrimination, but not only, and cooperation, I would say, mostly. If you look at the Covenant on the Economic, Social, and Cultural Rights, you will find indications of the idea of solidarity and the need to cooperate among states. And I think even more wider, that would be the approach to be taken. Here we have to take into account what Simon Chesterman said in the beginning, that we need to just get out of this idea of us versus them. And the only way this can happen is through international cooperation and solidarity. I mean, this is the approach, and I think the approach will have to be through institutionalized, through international organizations, or through cooperation of states. If Simon thinks that could be possible, he seemed to be quite not optimistic when he began his this presentation. So that's what I would have to say.
Simon,
that was my job to add. That was my job to be provocative. No, clearly I hope states will cooperate. But what's been striking, and what I suspect is likely in the short term, is you will see ad hoc collaborations rather than large institutional. So we're already seeing, for example, Australia, New Zealand, Singapore, Canada, Korea talking about allowing freedom of movement between those countries. And the positive side of that is, it's, if you like, this idea of the coalitions of the competent, that you'll see best practices. The great danger of that approach, of course, is that in the medium term, it could really lead to an us and them. And the people who will suffer as a result of that will be predominantly in the developing world, because you could just see widespread discriminatory bans on movement of people from large numbers of countries, which will disproportionately be the developing countries, I suspect.
Ambassador, your thoughts on this? And I'm also coming from the viewpoint of when a vaccine becomes available eventually, if the pharmaceutical companies were to charge an enormous sum for it, such that certain developing states may not be able to afford the medicine, would there be a human rights response to this?
Well, obviously, we have to look at the international patent system. As I said, there's compulsory licensing, and it's been several countries have resorted to it as such. Obviously, I mean, pharmaceuticals in this situation, no pharmaceutical company will charge a hefty amount. This is my personal view. For a vaccine and look like the evil actor in this situation. But if it happens, and it might happen, there's methods to do it within the WIPO system that can take care of this issue. And developing countries, obviously, they can work within the system, the UN system and WIPO system, towards creation of some form of licensing as such. So I hope this answers it. But again, I'm not the expert on it. We need to bring some more experts, maybe in the future sessions, to talk more about this matter.
Thank you. This is quite an
microphone. Yeah.
This is an intriguing question from Trumpam, and it goes: there is definitely a dichotomy between the way Asian countries, and she names China, Vietnam, Singapore, and Western countries, such as the US, UK, and France, when dealing with the COVID-19 situation. I'm not sure if it is really a cultural difference, or the Asian countries happen to have gone through the SARS experience. Okay, but the question is, do you see a dichotomy in a difference in the way Asian countries as well as Western countries handle the situation? Is it because of the differences in attitude and approaches of people, as well as the governments in the two regions, and the outlook on basic legal concepts such as human rights governance in general? Professor Chesterman, since you're from Australia, but you have been in Singapore for many, many years, do you have views on that?
Sure, and I lived in China for a year, lived in England for 3 years, and America for 6. So I'll take the global challenge, because actually I wouldn't put it down to pure culture, but I would actually divide it into 3 types of responses, and it's a couple of variables. One variable is trust. Is there trust in the government? And the second variable is the nature of rights protection. And so I think what you've seen in many Asian countries, and to some extent European countries, is a degree of trust. but the rights dimension is a little bit different. So there are fewer rights protections in Singapore, for example. There are rights in the constitution, but these can be overridden by legislation. You have trust, however, in the government here, for the most part, and reasonable willingness to follow along with that. So you see, that's one dimension. But I would see America as being in a kind of different category, because there you do have rights protection, but you don't have trust. In fact, you have the absence of trust, and that's on display now with the very different responses across many states in the United States, the unwillingness of large portions of the public to comply with requests that can't be enforced in the way that, for example, Singapore and China have enforcement powers that can be deployed relatively quickly. And then marginal countries, like you mentioned, Australia. Australia, the Minister for Health right now has dictatorial powers and enforcement powers. And so this is unheard of in Australian history, but it's been justified by the crisis. It's time limited. And so I think Australia is also a challenge to that paradigm of the kind of Asian versus Western values. And the last thing I'll say on this at the moment is that the measure of this is problematic. That how you evaluate this is problematic because it's not process evaluation, it's output evaluation. And what I mean, more process legitimacy is being supplanted by output legitimacy. And this is difficult for lawyers because lawyers are all about process, whereas what's happening around the world at the moment is you're having governments say, trust us, you need to do these things in order to achieve a desired outcome. Everyone agrees on the outcome, but unless you have trust in the government, people won't agree to the process, and then it's very hard to reach that outcome. And so in Australia, for example, these dictatorial powers probably won't be problematic because it seems to be working. Whereas in countries like the United States, you have much less trust in government. And unfortunately, it looks like the United States will continue to be the country that suffers the most in terms of the human cost of this virus, at least for the moment.
Professor Pazartzis, have you observed a difference in the attitudes of the Asian as well as the Western world?
I just wanted to add a few words to what Simon said. It's also a question of the various domestic legal frameworks and the differences between them. I'm not sure if we can make this divide of states on one side of the world or the other. It's also the attitude of various parts of the world to the international protection of human rights, which we have to keep in mind. Interestingly, China, for example, is not a party to the International Covenant on Civil and Political Rights, but it is party to the Covenant on Economic, Social, and Cultural Rights, and I'm wondering what that will give in the future. But we have seen that even in Europe, I mean, even in homogenized, if you wish, areas, the responses have been different. I mean, the exceptions and limitations differ from country to country, even within, I mean, one area of the world. So, so of course, trust, trust, of course, is the basic. We've been trusting the people who have been talking to us for a month now, in particular, professor of medicine who's become very famous in Greece and worldwide for reassuring the public. But that is not only, that's not the only thing that's necessary. I mean, you need more, you also need the legislative instruments. And may I add one more point that we should add? We will need to see how, and I think I probably alluded to it, how judicial bodies are going to respond to this. At some point, they will be called to intervene, to respond, and it will be interesting to see how international or regional or domestic or jurisdictions will address these challenges. And I think we need to be careful because I see many people have asked questions about the judiciary and how it's going to work. We need to also take that in mind and see, watch the developments as they come from that part as well. Thank you.
Thank you. This is going to be our final question, and I'm going to combine a few questions together from Dumas Gratitude, Xie Xing Quan, as well as Verdana Yanchan Dani. Okay, and this is a question that has also been raised at last week's session about state responsibility, and in particular directed at a particular at a specific huge state. So the question is, can China be held liable for failure to promptly notify the WHO and other member states for the early incident of the COVID-19 breakout? Is there any measure for WHO to facilitate preferential price of antiviral and vaccine for those less developed countries? Ambassador, do you have a view on this?
I'd rather to have general question on the issue of state responsibility, not about China or other actors. I mean, there's going to be other actors and other states who are responsible actually in this regard, and they will assume responsibility for certain failures to do so. I'm not sure about the regulations of the WHO. I think last week's session maybe have tackled it better in detail, but failure to notify as such might be under the rules of the WHO as an obligation. But if it's not, is there customary rules which force a state or compel a state to act in a certain manner in reaction to the virus? I'm not sure there exists at the moment certain customary rules. There is the no harm principle. It can be said that a state is obliged to not to cause harm through its action or inaction. It might be a basis by which creating legal responsibility or triggering legal responsibility of the state. Again, that's why I talked about the need to have a legal instrument, binding legal instrument, whereby you can set the obligations in this regard. And at one point, when you don't share information, if, for instance, some country is having progress in developing a vaccine and doesn't share the information about it and the know-how, I think there should be some form of responsibility for this that would trigger obligations towards the international community.
I'm happy to give a less diplomatic answer because I'm not a diplomat, although I agree with everything that the ambassador said. Maybe just to highlight, because there's a lot of interest in this question, but a lot of that interest, I think, is misguided. The domestic suits, for example, being filed in the United States, in states like Missouri, have zero chance of success under the US Foreign Sovereign Immunity Act. And indeed, I think a lot of those domestic suits and the international posturing is not really about a legal action in any meaningful sense. It's about an effort to either deflect blame or to deflect attention for poor handling of the crisis. That said, if you were serious, there are kind of three avenues that you could imagine a lawsuit pursuing. One is domestic. Again, most countries have the equivalent of the US Foreign Sovereign Immunity Act, so that's a non-starter. It is conceivable you could have an international tribunal, but the International Court of Justice doesn't seem to be a starter. You could constitute a new tribunal. That's theoretically possible, but politically unlikely. The third avenue, which I think is the most likely, but still hardly a high probability, is some kind of international advisory opinion. And so the World Health Organization has previously sought an advisory opinion from the International Court of Justice on the threat or use of nuclear weapons. So you could imagine an international advisory opinion. And of the three avenues, I think that might actually be the most productive, because it could clarify some of the issues we've been talking about today, which are how states can and should balance their competing obligations when confronting a pandemic of this sort, hopefully with an eye to ensuring that we don't make some of the mistakes that we've all made this time around, learning to deal with coronavirus and COVID-19.
Professor Beckman, do you want to express a view on this? Earlier, you have stated that you don't see this as a question of state responsibility, but rather it is a situation for the world to get together, in particular international organizations to get together to plug what you call are the gaps in the system. So do you have any view on this question about state responsibility?
Well, my comment was in respect to international shipping in particular, where I believe that the issue can be resolved by the IHO working together with the International Maritime Organization. The International Maritime Organization is clearly a body that, through the Safety of Life at Sea Convention, through the Convention on Standards of Training, Watchkeeping, and Certification, can actually impose binding rules on all flag states that would be able to deal with this issue, including on cruise ships. And because the rules adopted or procedures of the IMO, when they're under SOLAS, if you have regulations that are imposed, they become automatically binding on every member of the United Nations, which means every party to the convention, which is almost all members of the United Nations. So in terms of rules governing cruise ships and what safety measures they must have, whatever, that problem can be resolved. In terms of the bigger tension between rights of entry of vessels and rights of seafarers entering, I think there you need some protocols or some guidance, perhaps by bringing together port states and the shipping industry and ship owners to work out some standard procedures. My own view on these issues with respect to shipping, I think the pie in the sky resolutions and advisory opinions are not really that relevant. They are certainly relevant in some states if they're not protecting refugees or non-citizens within their own country and human rights obligations. But with respect to the narrow shipping issues, I think the existing international institutions can resolve the problems. And they usually act and pass new regulations in response to catastrophes, and this is a catastrophe. And it's in the common interest to resolve the problem. So I'll just stop there.
Thank you, Professor. Okay, more than 1.5 hours have simply zipped by. I would like to thank all our panelists, as well as our opening speaker, for an absolutely fascinating discussion on a very, very important topic. I also want to thank, I see there are still 270 over participants who have stayed with us all this time. Thank you very, very much for your attention and for joining us. Even though we are all logging in from our respective homes, can we just give a round of applause to our panelists? Thank you very much. On behalf of the Center for International Law, we hope you would also sign up for and log in to next week's session on COVID and trade law. Thank you very much.